Hi, I'm Shaye Larkin. I'm a San Francisco bankruptcy and tenant rights attorney, and one of the services I provide to my clients on a regular basis is I help tenants get their security deposit back from the landlord after they moved out and the landlord has taken the deposit illegally. This video explains the bad faith penalty for the landlord's wrongful retention of the security deposit. This video is based on California law, and watching this video is not a substitute for sitting down with your own attorney and getting specific advice about your specific situation. Now, if you're watching this video, you're probably facing a situation where the landlord is giving you a hard time about returning your security deposit, or you expect them to give you a hard time and you're trying to prepare yourself by getting together as much information as possible. You should know that you're not alone. Many tenants find themselves being charged inappropriately by the landlord for repairs and cleaning after they move out, or the landlord simply takes the security deposit and does not even bother trying to comply with any of the statutory requirements found in California Civil Code Section 1950.5, the Security Deposit Statute. These requirements include, but are not limited to, 1. The requirement to send an itemized statement to the tenant within 21 days of when the tenant moved out, which clearly shows the basis for any charges to the security deposit. 2. Providing the departing tenant with the required documentation supporting any charges, including invoices for any work done, receipts for materials purchased, and photographs taken both when the tenant moved out and after the repairs and cleaning were completed. And 3. The refund of the remainder of the security deposit. Many tenants choose not to fight the landlord's wrongful retention of the security deposit, and so the landlord gets away with it. Because of this, many landlords assume the tenant will not challenge them and become emboldened. You should know that California Civil Code Section 1950.5M provides for a penalty of up to 2 times the amount of the security deposit, in addition to the wrongfully withheld amount, for the bad faith claim or retention by a landlord of any portion of the security deposit. Note, however, that this penalty is not automatic. You must first sue the landlord in court and prevail. The burden will fall on the landlord, however, to prove that any deductions from the security deposit were both reasonable and necessary. You can show the judge the steps you took to try to resolve the dispute before proceeding to court. Examples of bad faith conduct on the part of the landlord would include 1. Ignoring your attempts to resolve the dispute. 2. Insisting on charging you inappropriately after you brought it to their attention that the charges were incorrect or invalid. 3. Grossly overcharging for repairs and cleaning. And 4. Willfully ignoring the statutory requirements for returning the security deposit without a good faith reason for doing so. At trial, the landlord will have an opportunity to explain to the judge why they believe their actions were taken in good faith. For example, if the landlord was late in returning the security deposit, but can show the judge it was due to circumstances beyond their control, then this may defeat a claim for the bad faith retention of the security deposit. If the judge finds the landlord has acted in bad faith, then they must award the appropriate penalty regardless of whether the tenant has requested it. To build a case for the bad faith retention of the security deposit, you should A. Document the property's initial condition by taking pictures and video at move-in. B. Take pictures and video at move-out. C. Keep all receipts for any repairs you've done or cleaning. And D, document any communication you've had with the landlord, including all emails, voicemails, text messages, and demand letters that you've sent to them. This has been a discussion of the bad faith penalty, and thank you for watching.